do you know about deemed disposition? Hi, Nancy Beauvert here with Agape and NEXsteps, and I wanted to talk today about deemed disposition. Now, some of you here in Canada may be familiar with that term if you have looked at leaving residency in Canada for any period of time. If that's the case, then what happens is the CRA takes a look at your assets and they give you what a deemed value is of all of your assets at that time and apply capital gains taxes to those so that they get their share of the tax dollars before you actually become a non-resident of the country. Now, what many of you may not know is that that deemed disposition also takes place when you die. So if you haven't had appropriate advice in how to shelter your assets, your beneficiaries, your heirs, your executor could end up with a bit of a nightmare taking care of things after you've passed away. For instance, if you have an RRSP, and let's say that that registered retirement savings plan is worth $4 million. You've saved over the years, you've contributed, it's grown, and now it's worth $4 million. When you die, the government looks at your assets as though they have been sold and liquidated on the date that you die. That means that that RRSP that was worth, sheltered, $4 million, now is going to come into your accounts as income, and your estate is going to be taxed on that $4 million. Now, how does that affect you and your heirs and your beneficiaries? Well, there are some ways to protect some of your assets. For instance, your primary residence most likely is not going to fall into the category of a deemed disposition. But if you have rental properties or a holiday, a cabin, a vacation home, that can be subjected to capital gains tax as a second residence. Also, any of these registered plans, any other assets that you have will be taken at the fair market value of the date of your death, and that tax bill will be forthcoming. Now, that can make great implications as far as what is left for your beneficiaries and your heirs to inherit. If your estate isn't very liquid, it can also create some headaches for your executor. Your executor is obligated to make sure that your terminal tax return is filed and to make sure that any outstanding taxes are paid. If there's not enough liquidity in the estate to cover the tax bill, your executor may have to look at selling some of those assets in order to cover the tax bill, because the tax bill is going to be paid before there's anything left for your beneficiaries. So how can you avoid that kind of pain for your executor to have to go through and to protect your beneficiaries and your heirs? The first thing that I would suggest is make sure that you get some professional advice. For instance, I'm a certified executor advisor. I can come and I can work with you as you're structuring your estate to make sure that you have the proper protocols in place, that you're working with the right team to make sure that your assets are protected so that in turn your heirs and beneficiaries are also protected. Also, make sure that you're working with a financial planner and somebody who is well versed in structuring your assets effectively for tax management. There are multiple strategies that can be employed to protect your assets from some of these tax implications. You know, in some cases, if you have a partner or a spouse, you can pass on certain things to them, but that only shelters the tax until that person passes away. So there will be planning that will be required by that person. And also there are only certain people who would qualify to be able to receive those assets without the tax implication. There are things like alter ego trusts or other kinds of trusts that you can structure and set up. There are things like purchasing insurance to cover the cost of what the taxes will be, so that when you do pass away, the insurance will pay out, and that will take care of that tax liability. And if you have a little bit extra, it may give a little bit of leeway for protection for the executor having to be out of pocket to cover any carrying costs or any costs of managing any of your affairs, any of your assets that are in your estate, until such time as the grant of probate has been received and the executor can actually deal with your estate and your assets out of your own estate. I have an article on the website this week that talks in more depth about some of these strategies that you can do, what some of the implications are, and how to help you be aware so that you can structure your estate a little bit better. I'm happy to help you with any of your estate administration issues or any of your estate planning. Hop on over to the website and reach out, and I'll be happy to schedule a meeting with you. Thanks very much for joining. I look forward to talking to you again next week. Bye for now.